call this meeting to order. The chair notes there is a quorum present. We will do the flag salute. Folks, the flag is right there behind you at the door. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, first up is 2.0, additions and revisions to the agenda. Commissioners, do you have anything?
Don't have anything.
You sure, Pat?
Yeah, I might want to pull something out of the consent agenda when we get to it.
Okay, let's go into correspondence and public comments. Individuals wishing to address the county court may do so at this time and at other times throughout the meeting. Speakers are asked to raise your hand to be recognized by the chair, give your name and address, and limit comments to 3 minutes. For folks who are signing in or dialing in on your phone, it is *6 to unmute yourself. If you are on the Zoom on your computer, it is the lower left-hand side of your lower left-hand corner of your screen to unmute. And as a reminder, we are pretty informal as we go through this. So if folks have questions, input as we work through the agenda, we welcome that as well. Any public comment at this point? Okay. Under correspondence, we have a couple of things I wanted to note. One, we have a letter from BLM. Basically, we regularly get information from them for feedback on different projects that we're working on. Right now, the one that's in here is related to a programmatic environmental impact statement and resource management plan for updated utility scale solar energy planning on federal public lands. So for those who are interested in seeing that, that letter, it's always part of the court packet online. Go ahead.
Did we respond to that?
We have not. Would you like to respond to it?
Well, it was like the 10th of March and I respond. Yeah, I mean, that's just kind of a big issue around the state. I know Lake County's really involved in it, but chance to site solar in places other than in farm ground. And want me to respond? I mean, it's probably too late. I'll find out. I'll talk to James in Lake County and see what he says.
I think it's worth reaching out to them.
Okay.
The other thing to note in there is that our treasurer has provided a treasurer's report that included the bank statement, fund balance summaries for January and February, and revenue expense report for February. So again, if folks would like to see that information, it's part of the court packet, which is online. It's part of our transparency efforts. Anything on that? Leah, did you have anything?
I would like to thank Nathan for supplying that to us. So,
great. So we actually are 2 minutes ahead of schedule from when we can reopen the lead assessment hearing. So would you guys like to go ahead and take care of the consent agenda and then we can come back up to the hearing?
That's fine with me.
Anything you wanted to pull?
Yeah, I just want some clarity. I guess I didn't completely understand the 5.4, exactly what that.
Hey, Kelly,
Yes.
can you just give a real high level overview of the CAFA grant and what that does for the assessor's office?
Yeah, just a second. Chet's coming in
Okay.
here.
What was the question?
We just need a high level overview, Chet, of the CAFA grant and what that does for your office, what it is and
So I wasn't ready for this. The CAFA grant is revenue that we receive from the state of Oregon. So we pay them portions of the fees from the clerk's office and interest that is accrued on back taxes. And then the state sends us approximately, it's around $80,000 a year that we receive from them through the CAFA grant to help support A&T functions. So the costs of our office to operate.
it's a good thing.
I knew it would be. I just was a little,
Mhm.
looking through the packet, I thought I'd better ask.
Thanks, Chet. Any other questions on the consent agenda?
No, I have a couple corrections on the March 1st meeting, and I gave those to Miranda. Correction on spelling theater and Alvin Grid, so
So those would be as amended.
yes.
Okay. Do we have a motion on the consent agenda as amended?
Yeah, I move to approve the consent agenda as amended.
Second,
It's been moved and seconded that we approve the consent agenda as amended, which consists of consider approval of March 1st, 2023 regular meeting minutes as amended, consider approval of March 1st executive session minutes, consider approval of March 9th, 2023 special meeting minutes, and consider approval of county assessment function funding assessment or CAFA grant resolution. So further discussion? All those in favor?
aye.
Aye.
Aye. Any opposed? Motion carries. Okay, we'll go back up to 4.0, which is a hearing to receive public comment on ordinance number 2023-01, fiscal year 2023-2024 Gilliam County Weed Control Special Assessment. This is the time duly set and advertised for a public hearing in the matter of ordinance number 2023-01, an ordinance for Gilliam County Weed Control Special Assessment for fiscal year 2023-2024. The rate for fiscal year 2023-2024 has been proposed at 7 cents per acre. Hearings are conducted in accordance with ORS 569.175 through 569.620. This hearing is for the purpose of gathering evidence as to the need for, identifying who will benefit from, and to take input on the special weed assessment rate. This is a legislative hearing. All those in attendance that wish to testify are asked to sign the attendance sheet or just raise your hand and ask to be acknowledged. The hearing is now reopened, just as a reminder, so folks are aware, we actually began this hearing about 2 weeks ago in conference, so this is a continuation of the hearing. Folks, again, on the Zoom, if you are dialing in on your phone, it is *6 to unmute yourself. If you are on your Zoom platform, lower left-hand side of your screen to unmute. The hearing is reopened, and so we did the staff report during the last meeting, so I will just ask if there is any additional public testimony that would like, anybody who would like to provide testimony on the ordinance.
Hi, Krebs, landowner, north end of the county. I would speak in favor of the assessment. Weeds are continuing battle, and takes a coordinated effort to stay on top of them, just not landowners alone. So I speak highly in favor of the assessment.
Great. Anybody else? Let's give folks a minute on the Zoom to unmute yourself. You don't exclude anybody. I'm not seeing anyone. Anything else you want to add, Doug?
Just looking into a few more grants. They have fire rehab money that's available in the billions, and it's like a 50% match. I've been trying to go out and look at some of the places that have burned recently and to see if there was cheap. Annual grasses is what they're trying to get rid of and get more perennial grasses, which slows the fire down because it stays greener longer. And now that the snow's gone, I'll have a chance to go out and look at more. And then there's several other ones, but I was trying to look for more money. So, and I think we're gonna do some work for Krebs here, either this spring or next fall too, so.
Great.
Do you remember that Joe McGilligan asked about the knapweed bugs?
Yeah,
We need to catch him this spring.
yeah. Yeah, well, they have to, the plants have to start growing actively and it has to quit freezing. And once they do that, you can go by and look at the plants and we can gather some up and take down and release for him, so.
I'd appreciate it.
Any other sort of last call for any public comments before I close the hearing? Anything back there? Don't see anybody here. Okay. We'll go ahead then and close the hearing. Hearing is hereby closed, and commissioners will move into consideration possible first reading of ordinance number 2023-01, fiscal year 2023-2024 Gilliam County Weed Control Special Assessment. Leah, since you are new, typically how this goes for an ordinance is we have to do a first reading and then a second reading at least 13 days later
Okay.
before we can move to adoption. And it's a two-part motion, which you'll see the language in your packet.
Okay.
So I move to have the first reading of ordinance 2023-01 by title only.
Do I second?
You
Okay.
can, or I can second. Second is up to you. It's been moved and seconded to have the first reading of ordinance number 2023-01 by title only. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay, in the County Court of the State of Oregon, in and for the County of Gilliam, ordinance number 2023-01 in the matter of a special weed assessment within Gilliam County for fiscal year 2023-2024.
I move to accept the first reading of the ordinance 2023-01 by title only.
Second.
It's been moved and seconded that we accept the first reading of ordinance number 2023-01 by title only. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. All right, we'll plan, Doug, on getting the second reading scheduled the next meeting, April, and then we can
Yeah.
adopt it.
And I actually have a meeting at 1 o'clock in Boardman on the car and rush deal. And I'll find out a lot more about that today.
Great, fantastic. All right, let's move on to unfinished business. 6.1, discussion and possible action regarding ORS 51.2605 relating to paid time off for justice of the peace. I believe Judge Patton was going to join us.
No, he has 16 traffic cases, 3 criminal cases, and had to be an interpreter for 3 of those, so
Ooh.
he has court, so. But she said, go ahead.
Okay,
So I would like to declare a actual conflict of interest as she is my sister.
okay, duly noted. So, Leah,
Okay.
how do you want to proceed?
Does she want to try to make it later? Do we need to?
No.
Okay.
Go ahead.
Okay.
She wants it, it's been on the, she's glad it's on the agenda. and she
Okay.
wants to go ahead and be
Perfect.
done with it today.
Okay, so I talked to Chris Patno, the Justice of the Peace, and then she sent the following agenda item to Delaney. The solution to comply with law, ORS 51260. Do you want me to just read what she said on here, or?
Yeah, that's fine.
Okay, hello Delaney. Commissioner Watkins asked that I send you any documents relative to the settlement of the matter of vacation accruals for the justice of the peace. So that matter may be acted upon by the county court on March 15th, 2023. Truman Stone, attorney for the Gilliam County, and I worked together on this matter. He indicated on November 10th, 2022, he would be communicating with Gilliam County regarding my proposal to settle the matter. Mr. Stone verbally stated in a phone conversation that I'm owed time under the statute. Below is my proposal. This was an email that was sent on December 6th to Liz, Sherry, and Pat. Vacation accrual matter. County Court, for the last several months, I have been communicating with Truman Stone regarding settling the matter of my vacation accruals. I presented him a settlement proposal of payout upon retirement at 3 years times 80 hours per year. And also holding Gilliam County harmless from vacation payout going forward, ensuring I take 80 hours leave per year through my term of office. Mr. Stone indicated on November 10th, 2022, that he would present my proposal to Gilliam County, which was nearly a month ago. I have given up 17 years of potential leave payout, so I feel this is very fair offer. I did not see the matter on the Gilliam County Court agenda, which seems to be very light agenda. I'm respectfully asking when this matter will be considered. And then she included a
So Delaney added the ORS.
Yeah.
Saying that. And it's number 5, which I'll just read for the record so folks understand what the request is related to. It states every justice of the peace is entitled to 2 weeks paid vacation every year, and during such absence, the county court may appoint a justice of the peace pro tempore pursuant to the provisions of subsections 2 and 4 of this section. Okay, so what I would like to do is have an opportunity to talk to our legal counsel about this. And so we are going to be moving into an executive session. Everyone can sit here, pursuant to ORS 192-660-2H to consult with legal counsel concerning legal rights and duties regarding current litigation or litigation likely to be filed. So here's what we'll say. The Gilliam County Court will now meet in executive session pursuant to ORS 192.6602H, which allows the court to meet in executive session to consult with legal counsel concerning legal rights and duties regarding current litigation or litigation likely to be filed. Designated staff will be allowed to attend the executive session. All other members of the audience are asked to remain in the public meeting room. So everyone can sit here. Folks who are on the Zoom, you're going to stay where you are while the court reconvenes in a private meeting room. Representatives of the news media are specifically directed not to report on or otherwise disclose any of the deliberations or anything said about these subjects during the executive session, except to state the general subject of the session as previously announced. No decision may be made in executive session. At the end of the executive session, we will return to the audience in the public meeting room. So folks, you can just, if you don't mind, can just sit tight for a little bit, and then we will be
Good to go.
okay. So are we on? Video is rolling. Okay, it is just shy of 11. Thank you everyone for your patience. We are back in regular session. Is there a motion?
Okay, I move to authorize county judge to work with legal counsel in line with parameters discussed in executive session to resolve paid vacation issues with the justice of the peace and execute any documents needed.
I'll second it. It's been moved and seconded that we authorize the county judge to work with legal counsel in line with parameters discussed in the executive session to resolve paid leave issues with the justice of the peace and to execute any documents needed. Is there further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion carries. And then please note, if you can, Miranda, that Pat recused himself and so abstained from the vote. Okay, let's move on. Go ahead.
So, but we're gonna get it resolved
Yes,
shortly.
yes.
Like, we're not gonna be, it took quite a while to get on the agenda. Kinda like to put an amen to this.
I think,
I'm just asking.
We basically just authorize legal counsel to finalize the document to do it.
Okay. We're just clarifying.
Got it.
Very good.
Okay, let's move into 6.3, Gilliam County Public Health Updates.
oh,
I
me.
see Leah's on, Leah's here, Dalene's on. I assume maybe Holly's with you as well, Dalene?
Okay, so we had our staff meeting on Monday, and then the update, they got the tobacco, I think you saw the ads they had. They got their dispensary license, I believe, and so now they can do that, and they're running an advertisement in the newspaper for the next 4 weeks. They did the tall cop presentation in Condon and Arlington. I attended the one in Condon. The guy was good. The kids seemed like they were grossly interested in it. I think it was sponsored by Community Counseling Solutions as well as the Public Health. And he talked about kids on Facebook and bullying and vaping, and which some of that was kind of a shocker to me. And then they're working with Chris on the emergency support functions plan. They're done with the immunization program. We worked on the budget, and yoo-hoo, the mask mandate in healthcare facilities will be removed April 3rd. So that's about it.
I thought it was April 15th. It's April 3rd, huh?
That's what it says, because we pick a random date and just call it, that's the end.
It's over.
Yeah. So that's pretty much it. Questions?
Daleen, Holly, anything to add?
This is Daleen. I just wanted to make a quick add. So the speaker that we brought in was from the Tall Cop organization. His name is Deputy David Gomez, but that was solely public health that provided that for the schools.
Oh, sorry about that.
That's okay. And then the immunizations, it's just, you know, all the school immunizations, working with them and the reports that we have to have to them. So that is complete, and all the reports have been submitted and approved. And now we just wait for the numbers to come back to us to give back to the schools.
Great.
Good job.
Any questions from the audience, people on Zoom, regarding public health? What's happening with that? In the room, I don't see any online, so thank you guys for that. Until next time. Okay, let's move into 6.4, discussion on Shuttler Flat Solar Farm concerns, tax abatement programs, North Carolina County Rural Fire Protection District Board. Who wants to go first?
I'd just like to start. There was an incident out on Shuttler Flat 1 week, 10 days ago. And Joe, if you want to say what happened when you guys went out there to address that.
So basically what happened is there's drive shafts that really low to the ground that run off electric motor that turns the panels to stay in the sun the whole time. And running alongside that's a conduit of power above ground as well. And what happened is just tumbleweed get wrapped up in it, yank wires and all that. And this whole farm set up that way. When they arrived, well, it ended up shorting out inside of the junction box where it's like 1,400 volts or something like that, but a lot of power in there. So there's nothing that can be done. Couldn't even drive to it anyway, because they've got everything packed in there. There's no driving around in there. And, but everything above ground and all that and that. So basically they had to sit there and wait for technicians to put on their bomb suits and all that, and go and unplug panels one by one. And before anything can be done, and then at that point we have no apparatus we can have there or anything, and so just be a fire extinguisher. And it's all good. And so yeah, the fire plan is non-existent. And their solution is, oh, we'll send somebody around once a day to go check drive shafts. Well, one of my firefighters there, he observed another drive line that was pulling on wires on that one as well. And so it's going to be a problem out there with fires with that. But
It's a mess.
that's that incident, but there's many more issues.
Yeah, in their site certificate, they're supposed to be developing a fire safety plan in consultation with North Carolina County Rural Fire Protection District to minimize risk of fire. So far, we've not had that contact with them. Upon beginning of operation of the facility, the certificate holder shall provide a site plan to North Carolina County Fire Protection. We don't have a site plan on hand. They're supposed to, this is their site certificate from the
site council.
site council. So there's a lot of follow through that hasn't happened yet. And we don't want to be the next East Palestine with a toxic cloud going over, because when those panels do catch on fire, they release toxic gases. And we don't really want to be putting our firefighters in a danger zone out there. So we were wondering if maybe we could write a joint letter between the North Gilliam County Fire Board into court to the siting council and say we need some follow through on what's in their site certificate. Because they don't have a vegetation plan in place out there. And it's just gonna be an ongoing problem all summer long. So,
I definitely.
So we don't have, we don't have them on the.
They were,
criminal.
we let them know that the discussion was gonna happen. It doesn't look like they're on.
So I will tell you, because I talked to Joe the other day about this, that I talked to Brian Walsh. And first thing he told me was when we were talking about the walkthrough, he says, well, that ain't gonna happen. Just logistically, they're not gonna do that. I mean, and he kind of said, well, they'll never do that. Then his next comment, when I talked about, you know, the toxicity of the panels, is these newer panels are not hazardous. They can direct lamps on everything else. But the issue here is if they get on fire, what do they produce with smoke and in the air that can come off of them? And we didn't have that discussion, but yeah, we need to do something here.
See, that's the thing, in solid form, the panels can be direct landfill. And with Renewable Energy Magazine, they publish is these devices contain cadmium, telluride, lead, cadmium, gallium. I'm not a chemist. Silicon tetrachloride and hexafluorophane. And it says when fire melts these elements, they create health hazardous smoke. And it's kind of not a big problem when it's just like a solar panel on a home or whatnot, but we're talking a lot of solar panels. And their basic fire plan out there is we'll stop it, you guys can stop it at Highway 19. Well, that means we're downwind. On a hot summer day, then we all have to be in SCBAs and that's not how you fight wildfires. And you get burned up pretty quick. And then you've got the homes downwind, and also evening time, the smoke settles down an 8 mile. And so there's a lot of issues. Yeah, they're great when they're in solid form, but not when they off gas.
without a vegetative management plan in place, it's just gonna be a continual problem. Which, at the earlier part of the meeting, you were talking about future siting of solar projects on BLM property in the county. I think when that opportunity does come along, we need to be in early and have some kind of a veg management plan. Jim and I think that should be grazing, because when they design these farms, if they would design them for the grazing component, we'd eliminate a lot of this. But as long as you've got exposed drive lines and exposed conduits, you can. But in the Midwest, they design them that way all the time. So I don't know why, the same way with the one at the bombing range, they've got all this exposed ground and then they don't have any kind of a vegetative management plan. So maybe that's for future reference when somebody wants to come talk about it. We need some kind of a grazing component to go with the solar.
Yep.
And that's part of what I talked about that last time is, involving the fire services on the very beginning of talks and all that to raise these concerns. And so.
Yeah, I don't know that they talked to our weed department, because I think their one comment that one time was that they couldn't find a union weed person.
Which are so represented by union.
That was their, they needed a unionized weed control person to be able to do anything with the weeds
Yeah,
there.
at that point, I guess it's just been put on hold until you get your ducks in a row, because all that stuff has to come to agreement before any construction would begin. This is the way it'll happen, and it needs to be.
So how do they enforce this through their permitting process?
So I think Sky is right on track that we need a letter that goes to the Energy Facility Siting Council staff. And they are the ones that actually hold the permit and set the requirements for Avangrids. All of the permitting, none of that goes through us. So we can provide input to AdSec, but we don't actually set the terms of it. But especially given that it was already part of their site conditions, we could, I think, make a strong case that they are not complying with their state requirements. And so then Department of Energy, usually what happens when we do that is we send a letter, we put FSEC staff, it's to them, but we put Avangrid on notice that we're providing comment. And in general, that causes them to, my experience is they turn things around pretty quickly to
We
respond
went
to.
through that with some of that process over other issues, so.
Yeah. So what I would propose, if the commissioners are on board with this, is I would be happy to take a stab at drafting based on the comments that you have provided here. And then if you guys can let me know who on your end would like to work on the draft, I'll do the first draft, but I want to make sure that I'm capturing your concerns accurately. And then once you guys are comfortable with the language, we would go ahead and submit it on behalf of the two entities to the FSEC staff that we've worked with on some of these projects, and just let them know that this is a concern. We need you to compel them basically that they need to come to the table and have these discussions. Does that?
I can be that contact person.
Okay.
As the chairman of North Gilliam County,
Okay,
and I can share it with Joe.
perfect. So I'll have Delaney make my notes. I'm hoping I'll have some quiet time on Friday and can put together a draft to get over to you. And then commissioners, are you guys okay with us just working out the draft and going ahead and sending when it's ready, or do you want to see it come back here? for approval?
If you could send us a copy of it, we could comment.
Okay,
I'd appreciate it. And then I don't think we need, I mean, as we move forward, we got to get it towards, we prove it at the end of the day anyway. But,
okay,
yeah, move things forward and then keep us in the loop, send us an email.
so we'll get a draft over to you.
Okay.
Other things that you guys wanted to raise?
I don't know if it's accurate or not, but article in the Times Journal says that the money from the pilot program, payment in lieu of taxes, would be split with the Soil Conservation District. And I'm a little confused on that. That's not true.
No, so kind of walk through this maybe, but the pilot itself, so under statute, the court can enter into an agreement with an energy developer for a payment in lieu of taxes agreement. And the statute limits the range of what that per megawatt amount could be, 5,500 up to 7,000. And so those funds that are coming into the county are split based on the taxing district's amounts straight across. So you guys will get your allotted amount based on all of those. What the court did was say to Avangrid that we are willing to accept a lower amount if you will provide some funding for some other priorities that we have. Part of this is based on their own permitting that was happening at FSEC, which is they came in basically and said that Montague Solar had no impact to agricultural lands. We obviously disagree if you're taking land out of production. And so our argument for Oregon Trail when we went back to FSEC was like, they need to provide payment in some form or some way of mitigating the impact that putting solar arrays on exclusive farm use has. And so the solution was that they would provide payments to SWCD that would be able to be available to producers who are still actively farming in order to support programs that increase productivity on lands that are still being used. So that's how that came about. It's kind of convoluted, but part of the reason for that is that they have been using the argument that putting solar arrays on prime farmland doesn't impact farmland. And because it's too small or because it's not irrigated or they use all kinds of things. Our argument is you're taking farmland out that is farmland. And so of course it has an impact. And so you have to figure out some way of mitigating that impact that would happen. And so the agreed upon solution was that they would be sending a portion of what they would have paid under the tax if we had settled for a 7,000 per megawatt to instead support producers. So we're not diverting like tax dollars into somebody else, but there was basically an agreement that they would find a way to mitigate their impact to having those solar arrays on what used to be working farmland.
And that was half of the contribution.
Correct.
The other half went to the port for housing, which the county is in trouble with on housing, with the direction that money would go towards housing. And it's always, I think, a decision you have to make at our level on, do we lose? We don't get anything if we don't get a project. We get zero. We're not gaining anything we can't get. So you don't get these projects without some type of tax abatement, because they'll move next door and do them. They'll move to the Midwest and do them. They'll go to other areas. So you got to have some incentive to even get them here. And so you look at what's the best way for the community and the county to get what they can get out of it, plus gets enough incentive for them to come build the project, because it's long-term. The project you're just talking about with fires, $25–30 million revenue to the county over the next 25 years. And so it's a lot of tax revenue that's coming in if we don't get those projects that are extremely helpful to us. So the fine line for us is to, make sure we can get them here, give them enough incentive to get them here, but don't sacrifice too much in that process. And it's difficult.
You might note that they only wanted to pay 500 to begin with. So.
And I've been.
Yeah, 500 per megawatt, and we at least got them up to the 1,500.
And I've been working a bill that's in session right now that, in fact, it has a hearing today, that wants to reduce the 5,500 to 7,000, to 1,000 to 3,000. And I've been on since I found that out about it Friday, on the phone all weekend. I'm in Salem talking to people Monday and Tuesday about it, that hopefully can, shut that process down, because we're not interested in that.
Okay, so the max is 7,000 per, I don't know what,
Megawatt.
and you've negotiated down to what?
Well, they can do 5,500 to 7,000. We let them negotiate down to 5,500, but we made them pay the 7,000. The 1,500 was in a community contribution split between the port and soil conservation.
Okay, you just stole our tax money. You negotiated away the tax money that should have come to the fire district without us even knowing it. You've given our money away because the company is paying essentially up to the 7,000. But we took a chunk out of it, instead of it going to the districts, the court has decided where it goes. So you've negotiated away income to the fire district.
Yeah, I guess my comment to that is, in all these projects, we're Gilliam County with 1,900 people, and Joe and I talked about this the other day, is the south end of the county doesn't get anything on these north end projects at all. And this is a distribution throughout the county for a small portion of that tax revenue. And
The fire district went through the spreading of the money when SIP came around. The court came to us and said, let's spread this money over the entire county. And so, again, our money would be used on the south end, all through the county. And we said, no, right in the description of the bill that authorizes SIP says that the money goes to the districts in which the project is in. So we've been through the same thing before. And eventually they said, yeah, you're right. The SIP money has to go to the districts that the project is in. And so we're repeating history here. We're doing the same thing. You've negotiated away money that should come to North Gilliam County and the North Cemetery and the Health District. You negotiated our money away without our knowledge. And I think it's that you violated the statute as written.
well,
I mean,
Those
we
are all
this
good
was-
projects.
this was in,
All good projects,
yeah,
but-
this was notified in public meeting for discussion as we went through this whole process. And I mean, I don't know how to get people to show up and help us make decisions. but they don't.
Well,
And then what happens, we make a decision and you're upset about the decision we made. And I don't know, this was on, I don't know how many meetings we went through,
3.
discussions, 3,
Yes, sir.
to get through this whole process. So it's,
first I saw it was in the paper.
In addition, I would also say that we believe, and I think this will play out. If you look in the court packet that was included, the amount, granted, you are giving up some money, but the amount that you guys are giving up is around $3,000 a year. We're investing that instead in developing housing, which also builds your tax base. So while you can make the argument that we're taking $3,000 out a year, $45,000 over the life of the agreement, we are also allowing the port to invest $500,000 in creating housing that is boosting permanently your tax rates, your tax base.
Rural, if it's city housing, whatnot, we don't receive taxes from city, we're rural.
Built inside the city doesn't do any good. But again, I think you negotiated away our money without us even a seat at the table. I think you got a problem. I think you violated, negotiating down that number is essentially, that's the number that should have gone to the special districts in the county. I think that's wrong. Granted, they are wonderful projects, but I think you may have violated the statute, especially when it is, you should be paying 7, but we'll take this if you do this.
It's not that, though. The county, under the statute, has the right to negotiate between $5,500 and $7,000. And all of these documents were cleared by legal counsel, who specifically has energy in their portfolio. So I appreciate that you're frustrated by this, but trust me to say that we are well within our legal parameters as the court to decide what that number will be. And I just also want to say, just as a little point of frustration, maybe on my part, is that in 2020, when Montague Solar went in, Avangrid came to us and asked us to do a red zone that had multi-million-dollar implications for tax districts. And we sent everybody letters, asked you all to show up and give us input. I will say for the record that I was the one court member on that court who voted against it. And I didn't see any of you taxing districts showing up to advocate for your money then. And it was hundreds of thousands of dollars, not $3,000 that you guys gave up in that. And I was there, I'm not even from the North End, defending your right to that. And not one of you came to ask us not to do that. So I appreciate your frustration about this piece, but I also have been down this road before where we have actively asked you to come to the table, all of our taxing districts, and you didn't come for much larger sums than what we're talking about here.
So you were to send a letter to the district?
Absolutely. You were required, when the red zone, all of you got them notifying that you were about to lose hundreds of thousands of dollars in tax revenue. The total giveaway, I think the assessor's office is calculating, is close to $10 million over 3 years. And I didn't see any of you at those public meetings.
Yeah, I haven't seen the letters that have come.
Those were in 2020.
Okay, I was on the board at
Yeah.
that time.
So I appreciate that you're frustrated about this, but I also say, we have a history of reaching out to you guys and working and encouraging you to give input. And I, as the one person who voted against that to try to protect your tax income, sure would have liked you guys to show up and express your concerns when that was happening.
Okay, so as I understand it, you feel you're within your rights to negotiate from 7,000 to 0 to our district.
No,
No,
We actually, Avangrid started at 5,500.
5,500.
5,500
was
is
going to
all
your
they
district.
wanted to pay with an additional 500.
Okay,
So we didn't negotiate down.
by
Right.
We
statute,
negotiated up.
But still, you're saying you think you're within your rights to negotiate from that 55 down to 0 going to our district.
No, you
guys
got the zero,
stopped.
you got the 0 to 55.
Because the state legislature law says we can never go below 5,500.
You got all that.
So every percentage of that 5,500 that is in the agreement, all of the taxing districts will get their
All got
percentage.
that. The only thing that was negotiated was between the 5,500 and the 7,000. The 5,500 went to the taxing districts.
And yeah, the statute is clear that that is the court's prerogative to decide what that number will be.
They wanted to pay 5,500.
To determine which number. The 50, between 55 and the 7,000.
Correct.
And in the statute, it says that you can take the money in between there and do whatever you want with it.
There isn't money in between there.
It's additional.
So the agreement, if you look, the agreement actually is just for pilot, how much tax revenue or payment of new taxes is going to come in. These other agreements that happened were not with the county. They're with the port and with SWCD from the developer. So those aren't our agreements. We just insisted that if we were going to accept the lowest amount, we wanted to see community benefit elsewhere in the system.
Do you follow, Jim?
Yeah, I follow.
Yeah, the 5,500, whatever that number was going to be that we could settle on, was going to go to the taxing districts no matter what.
Right, understand, but it could have been, Evergreen, you have to pay 7,000, and that goes over to the districts. It could have been.
It could have
Could.
been.
Okay, all right, and that's what I maintain.
Anything else on this?
One quick closing comment. It's amazing how we all carry these communication devices and we still lack communication. So if there is further communication between the court and the district, we will definitely try and do our part to help me that. It's unfortunate nobody was at that meeting. I don't recall it either, but that's where it is. So
Well, I would really encourage the residents of Gilliam County to look at the public notices. We have meetings every first Wednesday of every month and the third Wednesday every month. We've made an effort to make sure that half of them are in Arlington and half of them in Condon. And we got a lot of stuff going on that's really wild right now. A lot of big initiatives and a lot of things going on. This stuff that concerns you, please look at the agendas for those meetings and show up and help us make these decisions. That's all I ask. It's miserable to sit here and not have any participation until a decision's made and then get our hind ends chewed behind the fact after it's made when we didn't get any help.
I totally understand.
It's the most frustrating part of this job.
Yeah, the only thing I said previously was, with the previous court, when we were going through the SIP negotiations and all that, actually, the judge, put herself on our agenda, came to our meetings, discussed it, and so it wasn't, and nobody showed up to us. They went out and did this, and sometimes that, helps as well. A little bit of reaching out before.
Well, you and I talked about it the other day, and I think it's important for us to do that, whatever we can do to try to include you in it, and then if you want to.
Yeah, and that includes all districts, I suppose. I'm not just talking just us.
Sure.
Which is great. You're sure work forward into the communication that way. It'd be awesome. And my only last thing I forgot to mention was we do have the fire marshal looking into the site out there, because if there is no farming being done on that whole project, and so therefore it takes it out of agriculture into industrial, and he's going to be looking at what type of things that can go from the fire marshal end as well on that. It's like, now it's an industrial site. It's different from the windmills, because you can farm around windmills, but you can't do nothing with this site. So that's.
Can I clarify in the letter that we're going to draft? what the ask is. So is the ask that we are asking for Avangrid to set up a meeting as soon as possible with the fire district to talk through the fire plan? Or what is the ask that you want us to convey in that letter?
All was on this side.
Compliance.
None of this has been done.
Okay,
And that's something that needs to happen. We showed up on the call and was completely unprepared. Nobody's been in that, and nobody had any verbal communication on what to do if there's a call. And so that was just a opener. So, okay, well, we can't do that. And so that's a site plan, I guess.
yeah,
Is
okay,
do nothing and then fight it downwind, and we can't fight it downwind. So what do? And then you have adjacent landowners when that fire crosses onto their property, because we weren't able to send there in the smoke to stop it. Now they got lawsuits, I guess, because it's burning up the next land that they had no fire plan for.
Yeah.
So, yeah, it just turns into a big problem.
mhm,
Well, and they should at least let you know what kind of chemicals you might be exposed to.
Yeah, well,
If you
their
do
first
so.
thing is all these things you can direct landfill. You can direct landfill a lot of things, but when it burns, that
chemical
puts off
reaction.
very toxic
Yeah.
fumes.
Oh, the other
So that's a-
thing-
That's a different thing, and that's my concern is fire.
Well, the other thing is they should have been in this meeting and they
Yeah.
were notified.
yeah, I don't see them on here. I don't think they popped up, even though we did say that they needed to hear this, so we will follow up.
I appreciate that.
Anything more on this one? Thank you guys so much for coming. Appreciate you letting me spar with you a little bit.
This is the site certificate and lists our concerns there. This,
Looks good. Okay.
I have a suggestion.
Yeah, sure.
Before you contact the siting council
Uh-huh.
for enforcement, maybe send a letter to Brian Walsh and give him a week to,
Absolutely.
it's just courtesy to.
Part of the reason though, I'd like to also include ESSEC, if you don't mind, is they are finalizing the rules for Oregon Trail, which is going to come in right behind that one. And so if they still have an opportunity to tweak some of those rules, I want to just kind of flag that for them as like, here's something we've already run into for Montag 2. Before they construct Oregon Trail, we'd like you to set some expectations that this is not going to be how it is for this.
So some of the stuff that's happened with Oregon Trail has been based on what has happened with Montag too.
And then the important thing there is to make it grazable.
Okay,
If you get sheep in there, that'd be great.
Yeah.
Problem solved.
It's right across from my house.
Yeah.
Got it.
you have a special, yeah.
It-
Special interest in that
It
one.
needs to be grazable.
Okay,
You know, the only other thing they could do is turn their panels on edge and spray the whole thing with an airplane. They gotta have a vegetation plan.
all right, we'll get on it. Pat, do you want to have a call with Brian?
Yep.
Okay. I'm gonna do a direct call to him, I think, and I'll start drafting a actual letter so we have it documented.
Great.
Okay, anything else on that? Thanks so much, guys.
thank you for your time.
Have a great day.
Thank you.
Okay, commissioners, how you doing?
I'm good.
Moving forward?
Mhm.
Okay. You need a break? No, we're good. Okay, all right. Miranda, you good? Yep. Okay, just checking. 6.5 is consider approval of position descriptions for public transportation director, public transportation coordinator, public transportation dispatcher, driver, library director, youth librarian, weed control officer, weed control assistant, juvenile and prevention services director, juvenile director, prevention services assistant, planning director, facilities director, facilities maintenance coordinator, custodian, senior and family services director, senior services coordinator, senior meal site cook, senior meal site assistant cook, and assistant commissioners employee resources officer. Commissioners, I did a pretty detailed kind of for each of these position descriptions. What would be helpful in terms of how to approach these? Do you want me to go through just high level 1-by-1 changes? Or
I kind of read through them, so.
the one request I have is, since this came out, the incumbent planning director had reached out and said she is currently at 37.5 hours and is interested in moving to 40. Under the CBA, as long as management and the employee agree, that can happen.
Yep.
And so if you guys have no objections, I would like to amend the planning director.
Now, that was one of the purposes to negotiate into the CBA that we could allow them to move to 40, which helps us with all of our.
Correct. So
payroll
if there's
stuff.
no objections, I'd like to amend it to do 40 hours FTE for that one. Ellen, go ahead.
Would you like questions after you go through the descriptions or before? Regarding the job description.
You can ask them. Commissioners, do you have anything? Go
Yeah,
ahead.
whenever.
Ellen Wagner, Gilliam County Clerk. I knew there were gonna be, reviewing job descriptions, but I guess I didn't realize how many positions you were taking out of the union. And I guess my question is, why? I see there's gonna be 7 employees removed from the union, which is 28%. Is there a particular reason why you were taking them out of the union?
So the idea behind this, two of the employees, the library director and the weed control officer, are supervising already. My understanding, as I've learned more about labor law from other negotiations that I've done on other boards that I sit on, is that actually once somebody is a supervisor, the management can decide whether they would like to have those people included in the union or not. And so for 2 of those positions, 2 that are coming out, because they are already performing supervisory duties, I think the thought is we take them out, we compensate them as, and have expectations for them such that they are supervisors. That would be Mary and Doug, obviously. For the other positions, we are talking about creating basically 3 new positions. But the way this will work is that we have incumbents who are sitting right now in non-supervisory positions that are represented by the union. We have created 3 positions that are outside of the union that are supervisory, or we would, assuming we approve this. Those incumbents who are sitting in union positions, the juvenile director, the facilities, what will be the facilities maintenance coordinator, and the senior and family services coordinator, they will have the opportunity to go through training. Assuming they successfully complete that, they have the opportunity to be promoted into these new positions. And then their current positions will basically remain unfilled unless and until there comes a time when we need to fill them for county needs. So again, the idea is that we're treating all of the employees equally, that if they have supervisory duties, we are giving them the opportunity to receive training. We're giving them the opportunity to receive promotion, which is something we haven't been able to do really as a county for a long time. Because when you have 1 people departments, there's no place to go. And so this gives folks an opportunity to create skill sets, things for themselves that we wouldn't previously have been able to offer. And then also allows them to be compensated for being willing to fill those roles and learn how to be a supervisor and all of those things.
So I see where the coordinators could go to a director.
Correct.
And it will be changed from non-exempt to exempt versus hourly versus salary, correct?
No. Depends
Or
on,
just a couple.
it
A couple are.
it depends
a couple are
on the
not.
position. Because under state law, under state and federal law, in order to become salaried, you have to supervise at least 2 FTE. So some of these supervisors, for instance, the public transportation director position definitely has 2 FTEs underneath them. There are 4 part-time drivers, 1 full-time dispatcher, 3 FTE, definitely under salaried. The maintenance coordinator, or who would be the facilities director, once promoted, is supervising less than 1 FTE. So they would remain hourly. So it's going to depend position by position. The one exception to that is the Juvenile Prevention Services Director, and she will remain, she's currently salaried, she will remain salaried because she is coming in under a professional exemption, which is a specific requirement under the law based on the kinds of work she is being tasked with.
I know there's different types of exempts. And the one I read, one of them had the requirement to supervise 2 or more employees,
Yes,
but the others did not require that. So, but they can be exempt, so, but we're gonna keep them non-exempt.
who specifically are we talking
Okay,
about?
like, let's see. With the 2 you're changing. So you're doing the juvenile and the public transportation. No, juvenile was already exempt.
Mhm. Under a professional exemption, not a supervisory exemption.
Okay, so the senior family service coordinator,
Mhm.
you're gonna keep it non-exempt
Correct.
because it doesn't supervise.
No, it does supervise, but she's not supervising equivalent of 2 FTE.
But isn't that only one qualification for exempt? Because there's different exempt employees, and that is one of them.
Correct. There's professional, and there's also a Miranda and Delaney under one because they support the management of an entity, which is a separate exemption.
Okay, so. So I would assume, I noticed Shirley, you're not including the juvenile and prevention services director. You're not lumping them with your librarian and weed control officer to be immediately removed from the union. And I guess I don't understand that because this person is going to supervise the new position, the prevention services
Assistant, yeah,
and which starts April 1st.
yes.
So don't you need to bump her up?
No, because I can supervise the prevention services assistant while the juvenile prevention
So
services
should that be added to
director.
the job description? That supervise under the judge too, not just that.
Ellen, I think it's okay, honestly. These have been thoroughly vetted by our legal counsel. Ultimately, I have responsibility for that department. So for instance, if there was a vacancy, and
Well, I
say we
just
never
noticed
had a juvenile director.
You have county judge on some others. I just wondered why you didn't have county judge on that. So supervise.
Well, because if they're a direct report, then yes, it would be listed as they're directly reporting to me. If they're directly reporting to a middle manager, then it would be listed that they're directly reporting to a middle manager.
But the juvenile is you, right? They report to you?
The juvenile director does, yes.
So you're gonna keep her as juvenile director, and then you're gonna supervise the prevention service assistant until
Amy has the opportunity
qualification.
to complete yes. All of these, so this is not removing the juvenile director out of the union. It is creating a new position.
Right.
Which Amy would have the opportunity to be promoted into, assuming she completes the supervisory training, which all of these individuals will have to go through in order to receive promotion into the next.
So they have to go through the training to be promoted, but the librarian and the weed does not.
They are already, we're
Supervisory
already
position.
tasked with that. They will be expected to go through supervisory training because they have never had that. And so we will be asking them to do that along with all of the other people who are moving up.
Okay, so you are downsizing the family services position,
Correct.
and you are moving those duties to 2 different places, to the new prevention service assistant and the senior services.
No, so what is going to happen is the resource and referral piece of the family services coordinator. So when people come in and say, I'm having trouble paying my utility bill. Currently, depending on your age, there are 2 different people who provide that service. So Sabrina provides it for seniors, Teddy provides it for family and children. There's confusion often amongst the public and even sometimes amongst staff when somebody walks in the door on whose client it actually is. So the idea here is there will be a one-stop shop, which will be family and services, the family and services department. Sabrina, assuming she completes successfully her supervisory responsibilities, will be promoted into the director position. And so anyone in Gilliam County who has a need will have one person they can go to. There's no question about, should I be in family services or should I be in senior services? It's one department. And so for the current family services coordinator, the idea is once you remove those resource and referral duties, what primarily is left is prevention. It's youth experience program, youth work experience program, it's OICC. It's some of the community events that we are using where we're connecting families with resources, parenting classes, the early learning hub, those we all, at least I do, view as prevention. And so basically what we're doing is we're reclassifying the family services coordinator down to a prevention services assistant and moving that underneath the juvenile prevention services department. Because Amy's task really in the juvenile director is not just when kids get in trouble, here's what we do, but also how do we keep kids from getting in trouble in the first place. Doesn't make sense to have prevention in multiple departments when it should really probably be housed under juvenile. And then that way the coordination happens where it needs to, when it needs to, and I think it just clarifies where those responsibilities actually are.
It's just too bad you couldn't move the senior services to the family services to keep that position that somebody's worked for 22 years and has that experience versus you're giving it to somebody that has 5 years or less experience.
Mm-hmm. So would you anticipate under that, how would you do that without completely eliminating the senior services position?
I would give it to the family services.
So you would want us to eliminate the senior services position then?
Well, I think she has a lot of jobs. Well, she has meal site and she has her regular jobs now.
Yeah, but I would treat her regular job is resource and referral for seniors.
And transportation. She does a lot for transportation.
She does some, but a lot of it is overlap with her senior population.
So I guess how do you choose? How do you choose?
Well, I think I showed who would pick up prevention if we did that.
Well, why not the family services?
Because again, I think that prevention fits under juvenile. That is what Amy's real task is doing.
I just to downsize a job that somebody is devoted 22 years to, I guess I'm not seeing it, guys. I'm not understanding why you're doing this. Now, so what is the official date this job is in?
It is not ending. It's a reclassification of the position.
So,
We're not recruiting for a new prevention
so I
services
see you have
assistant.
15 hours,
Correct.
which why wouldn't you bump that to 19 like everybody else? But
Because I did a time assessment with the incumbent,
that's how you came up with it.
and that is the appropriate classification. And
So this person is losing their benefits. Effective.
so assuming the county court moves through with the position descriptions as they're written, that would be effective April 1st.
Okay, not March 31st, because the new job starts April 1st.
Correct. But if you're asking about whether health benefits would happen on April 1st,
Yes.
at midnight, no, because at midnight, the position becomes the reclassified version. And under our CIS requirements, you have to be benefit eligible on the 1st of the month, which would not happen. It would.
So your senior benefits would be done
Correct.
March 31st.
Correct.
You gave her 14 notice and you're ending her benefits March 31st. Wow. Okay. So we're gonna set the COLA for the union. Is the non-reps gonna be set later?
Thanks, Ellen. Anybody else? Joey, go ahead.
So I'll just use Sabrina as an example. She moves to the director. Would the coordinator's job just disappear, or it just stays, and then if need to be filled, it would be filled?
Correct, yeah, so it'll stay within, that's why it's included in the union salary schedule still. It'll just stay vacant basically until such time as the court decides there's a need to fill it. Other questions?
Yeah, I just want to say that I'm strongly opposed to your decision for my position. Just seems like obviously it came out of nowhere and was all of a sudden to the point of basically total devastation of a job, no benefits, nothing, basically just completely forcing me out of anything. There wasn't, like, you guys are talking about transparency. There wasn't really a discussion with me saying, hey, is this really exactly what's happening? I know you asked me to fill out some kind of a time study or whatever that you're referencing. I feel that everything that happens ebbs and flows all the time. I don't really see the reason to eliminate a complete position. Been here for almost 22 years. Seniority means absolutely nothing. And it's going to people who've been, 5 years or whatever, people that, I've helped train in the positions that they're in. And it's wrong. I've given basically half of my life to supporting people for Gilliam County. And now it's just gonna be adios because, you guys you're not stupid. You're aware that somebody has to have a full-time job to live. So offering me 15 hours is just really wrong. I don't know what else to say about it, but.
Your comments, questions? Folks from on the Zoom, if you're on your phone, it's *6 to unmute yourself. Lower left-hand side of your screen if you're on your computer. I will say, these are not easy decisions to make, and we have to balance constantly.
They are easy decisions for you to make. You do them all the time. You have a patience around you that is vast. You have a planning capacity and a manipulative ability that is ginormous. I fed into your model. I did your bidding, and I was relieved of my duties. I was a bad employee and largely under your direction before you were judge. So do not claim that you are holier than thou.
And who is that?
Rachel, do you want to identify yourself for the record?
Yes, Rachel Weinstein. And I have been quiet. I have been out of the public eye intentionally in deference to Judge Farrar Campbell. But she speaks with forked tongue.
Thank you for your input. Anybody else?
Like I said, it also seems a little unjust that we're creating jobs and putting out for them right now and eliminating positions rather than utilizing who you have and people who put their time in.
Well, Teddy, if you feel you have the qualifications to apply for the finance director, put it in. I mean, nothing is stopping you from doing that. And you know what? I appreciate that.
Dawn's job will be open,
Yeah, and
Ellen's office, December.
yeah, I appreciate that people feel heated about this. I understand it has a human impact. But there also has to be a responsibility for me and for the court. It's not fair to the public that pays all of our salaries to artificially keep FTEs open when there's not enough work to keep those people busy. And there has to be a balance between that. I know that that causes harm to people.
I have enough work. I had my position full. And I'm sorry if something didn't work out in a different position, but it doesn't mean you take it away from someone else.
But Teddy, you didn't, because the time stuff that I did with you shows that it's not a full-time position. Even as
You have been after Teddy since you were after me. You did it with Lisa. You failed, and now you're doing it again.
Thank you for your input. Is there any further discussion or questions from the public? Brenda, can you do the board so it pops up?
I have just killed us in town.
I know.
Hey, Rachel, you're not unmuted.
Yeah, so I did. I killed us within town. Yeah, you heard it.
I'm sorry, what? Not sure. Okay, so commissioners, questions about this, comments, things you want to dive into deeper?
Not me.
Okay. So this can happen as a slate if you guys would like. If you would like to pull things out, you're welcome to do that. For most of these, as you will note, a lot of this is just administratively cleaning up some things. So it's adding the driver requirements, it's adding remote work. It's Miranda and I were looking at the education requirements to make sure those are consistent amongst similar classified positions. And some of it is just cleaning up other, typos and things that we caught along the way. And then of course, some of these are new positions where we would be promoting in. One is a reclassification has been noted. And then the one amendment to the planning directors, which is moving that one to 40, the current 37.5.
Can I ask another question?
Sure, go ahead, Ellen.
So you're changing the planning director from exempt to non-exempt because she doesn't qualify,
correct?
Our assessment is that moving her to hourly is a better representation of the essential duties required of the position. Yes,
But you're keeping the juvenile director exempt.
correct.
And you guys understand how many extra hours the planning director puts in,
Correct.
which is will be a better deal for her if she gets the overtime.
Yes, it will.
And if you approve her to work overtime.
Correct.
She has a lot of meetings she attends, doesn't she?
Quite a few, and then the planning commission meetings are usually after work to accommodate the commissioners. Commissioners, questions, things that you would like to pull out?
So when the adding remote work section just means it's in the description, not necessarily that it can remotely work, right?
Correct. So what it is just at the top of each of those, it has a eligible or hybrid eligible or not. And then Miranda is working on putting together an actual policy. But as you'll note, in each of them, it says upon supervisor approval. So basically, it's just would allow the electeds and us who are supervising these various departments to, on a case-by-case basis, figure out what a hybrid, if somebody requests a hybrid work arrangement, what that would look like in expectations.
You want me to do it?
I don't care.
I move to approve the slate of position descriptions as presented and to authorize the county court staff to update the 2022-23 salary schedule for non-represented employees by adding the library director, weed control officer, and prevention services assistant positions and their current salary ranges.
Second.
Are you guys okay with the 40 change
Yeah, should we say as amended?
as amended, if that's okay?
As amended.
As amended. And Pat, you're seconding that?
I'm second that.
Okay, so it's been moved and seconded that we approve the slate of position descriptions as amended and to authorize the county court staff to update the fiscal year 2022-2023 salary schedule for non-represented employees by adding the library director, weed control officer, and prevention services assistant positions and their current salary ranges. Is there further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion carries.
Can I ask another question?
Sure.
So the library and the weed control officer, the salaries are not changing? Correct?
Until the 23-24 is written. The salary schedules.
Because it's COLA?
So we will be passing a new 2023-2024 salary schedule, which has not been for non-represented. And so at that point, we will be setting their new supervisory level. And in the intervening months between now and July 1, we're going to be asking those incumbents to go through supervisor training.
At the same wage.
Correct.
And the juvenile prevention service director will do the same.
Correct.
Create that in the 2023-24.
Correct. And that is going to give all of the potential people who could receive promotion about 3 months to go through supervisory training, which Miranda is working on putting together for them. Okay. Okay, let's move on to new business 7.1. Consider approval of letter agreement with AFSCME. Okay, so basically, I have been in discussions with AFSCME and gave them a proposal, letter of agreement. I'll outline it and then sort of say where we are. That effective April 1, 2023, employees in the bargaining unit would receive a 6.5% COLA, which would go through June 30th of 2024. Under those terms, the COLA, or currently under the collective bargaining agreement, that COLA would be capped at 3.5. So that's giving them an extra 3% for this upcoming fiscal year. The CBA would be extended by 3 years. As noted earlier, because the contract language specifically says that the planning director is overtime exempt, this would be changing that language to make clear that she is eligible for overtime. It also puts together an agreement whereby we are crediting the incumbent with 80 hours of comp time and then paying out anything over that she has accrued or would have accrued had she been hourly from July or January 1st, 2021. So we'll pull her timesheets, get those numbers, and then ask Ellen to cut her a check to cover any overtime hours. We have already done an initial assessment of that. It is not a huge amount. So that can move forward. The letter of agreement also captures, so it has those amendments. It also memorializes the action that we just took here, which is removing library director as a supervisor position, weed control officer as a supervisor, and services coordinator, which has been reclassified as a part-time prevention services assistant from the bargaining unit. Also memorializes that the 3 new supervisory positions that were just created, juvenile prevention services, facilities director, and senior family services director are considered supervisory, and so then not eligible for representation by the union. The union met last week. They have voted to accept the letter of agreement as presented, and so my recommendation would be that we accept it as well.
I move to approve the letter of agreement.
Do you have a question?
Yeah.
Can I ask the reason why you don't want to go into negotiations in the regular timeframe for the union contract?
So actually, the union had indicated to us that if we have offered a higher COLA, that they were interested in extending the contract and not coming back either.
So they came to you with that, not you. We did not.
There were conversations. Yeah, there were, Teddy.
Okay, so the union came to
The union indicated an interest in us providing an offer
regarding not going through negotiations.
for increased COLA, yes.
Yeah, an increased COLA, but not to not open up negotiations when they were.
Teddy, I appreciate that you weren't in those meetings and your union president was. So.
Because it's not reflective of the union if one person.
In general, what we do is we treat the union president with the respect that he is when he is asking for things, that we try to be responsive to that. And as you know, there was a previous LOA that we had tried to find an agreement on that the union rejected. When they came back to us, they said that if we had considered the higher COLA, they might have entertained that. And so that is what we provided based on union feedback.
And I will state, since I went through the last union negotiations, I don't think it was productive in any way for the employees, the county, or anybody. So if I can not have to do that, I think we can move more to more of a performance-based system. We're way better off.
So by doing this, the union can't open it back up within the 3 years, correct?
It's like any other contract.
But the judge can.
So the union can and has approached us to ask us to consider other proposals.
Okay.
And the contract stipulates that we can continue to have conversations throughout the term of the contract to negotiate changes in law and other things that have happened. And so our relationship with the union is going to continue just as it always has.
Okay.
which is that we will be good partners and be responsive when they have requests and negotiate in good faith and all of the things that we have been doing. But I also think it's perfectly appropriate as a public entity that if we are going to be providing higher COLAs, that we ask for something in exchange. That's not unreasonable when we are on our side giving more than we negotiated on the contract to ask for something in return. And we did that, which is a contract extension.
We've gotten outside of the CBA to set up some pretty, exceptional COLA increases that were not in the CBA. So we're not here to keep everybody pinched down. We're here to be fair. And I hope the employees understand that we'll be fair under all circumstances.
I mean, we contractually, for context, are capped at 3.5% for COLA, and last year we provided 8.1% and provided it 3 months early. This year we're getting.
I was just asking if you could open it up.
I think it doesn't necessarily open up the negotiations, but there's the letters of understanding for specifics to the agreement that are agreed on by both parties.
And we've done those on a regular basis. The union has requested we consider them, we've requested they consider them, and that dialogue is ongoing. Other questions, comments? Do I have a motion on the letter of agreement?
I move to approve the letter of agreement with AFSCME. Do I have to say it out? AFSCME as presented.
Second.
It's been moved and seconded that we approve the letter of agreement with AFSCME as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. 7.2, consider approval of modification to City of Condon fiscal year 2022-2023 special projects grant agreement. Delaney, do you want to do the overview? And then I think I see Catherine on the line too.
Yes.
Or maybe Catherine, do you want to just say what the city's request is?
I'm getting there. Thanks for, what we decided is that the grant we received, $20,000 towards a heating system at the play shed. And then as we got into it, we realized that until it was abated, that money, it wasn't going to be well spent. And so I reached out to Liz and just said, we could either give it back, or we have a project in the Memorial Hall of getting some air conditioning in there and redoing the floor. And so we're asking to move that money from the Condon play shed and moving it to the Memorial Hall. And it would probably it'll probably be after July that we would be able to get it done if this is approved.
So how much does the Memorial Hall get used these days?
You know, we have not had a lot of use in the last year since we've come out of the pandemic. But I do know that we can't hold blood drives or anything else while we don't have air conditioning. And that's one of the things that would be nice to bring it back down. We're hoping for more use now that we have spent some money on making the acoustics better. And we also have the smart board, thanks to the county in there. So we're hoping to get more use out of that.
I know they had the MSHA in there the other day.
They did.
They used to have some really good dances in there years ago.
You can set one up, Pat. I'll make you a heck of a deal.
Questions about this?
Catherine, would you like me to also extend the reporting date for the grant into maybe like September? Because usually the reports are due for this at the end of the fiscal year, so that would be June 30th.
That would be great. I didn't think about that. Thanks, Delaney.
Okay. So can you wrap that into this as part of what we're amending for the grant?
Yeah, so we would be extending deadlines too, but commissioners, I think you could just, if you're interested, just authorize the amendment, and then Delaney and I can add those into the agreement and get it executed with Catherine.
No, I move to amend the fiscal year 2022-2023 special projects grant award to the city of Cona by authorizing the grant funds to be used for Memorial Hall improvements and to authorize the county judge to prepare and execute an amended grant agreement reflecting the same.
Second.
It's been moved and seconded that we amend the fiscal year 2022-2023 special projects grant award to the city of Condon by authorizing the grant funds to be used for Memorial Hall improvements and to authorize the county judge to prepare and execute an amended grant agreement reflecting the same. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay.
Thank you.
Thanks, Catherine. 7.3 is discussion and possible action regarding community dispute resolution process. So do you want me to do this one? Okay. So this is kind of convoluted, but every biennium, the legislature grants funds for community dispute resolution services. And each of the counties is eligible for these grant dollars. In previous years, we did an intergovernmental agreement where Wasco, Hood River, Sherman, Wheeler, and us all pooled our money. Wasco County administered the grant, and that's how we handled it. Assuming that the legislature authorizes funding again this upcoming biennium and that it's roughly where it has been in past years, we are talking about a grand total sum of $1,192 for the biennium. So about $600 per year. We received a letter from Wasco County saying, apparently we had been doing this under the assumption we had to do it. Turns out we can basically have University of Oregon's Dispute Resolution Center do this on our behalf. And so Wasco County sent us a letter basically saying, hey, we're out. We're gonna just let U of O do it. And given the amount of funds that we actually receive and the fact that I think there is one eligible provider in our region who can do this work, seems like not a very good use of time to have to go through a whole grant process for what amounts to $600 a year. So the recommendation here would be for us to also opt out of managing the selection process, and then our funds would go and be managed by University of Oregon on Gilliam County's behalf, so that we don't have to worry about compliance with laws and all that kind of stuff related to this little teeny tiny sum of money. So before I just assumed we wanted to opt out, I wanted to get your feedback that that is indeed the direction you want to go. And if so, we would just send a letter basically to U of O notifying them that we are opting out and asking them to run a selection process on our behalf.
I am good with that. We have bigger things to worry about.
I thought that might be the case, but didn't want to assume.
I move to approve the letter to the University of Oregon opting out of the Community Dispute Resolution Grant selection process as presented.
Second.
It's been moved and seconded that we approve the letter to University of Oregon opting out of the Community Dispute Resolution Grant selection process as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay. 7.4, consider proposal for early education roadmap development and implementation support, aka Rocket 2.0. So as you guys are aware, last year we convened a resource organizer for collaboration kit. It could be anything, so Delaney didn't have to remember it off the top of her head.
Resource organizers for communities.
Oh,
did they change it?
Yeah. So basically we had a whole bunch of stakeholders come together last year, regional, local, and state partners, focusing on getting our arms around this childcare crisis in the county. And the group at the time identified a whole lot of barriers to actually solving this, but really only had time to really dig into two, which were workforce pipeline and what we're calling the childcare ecosystem, but basically home-based providers. So each of the little subgroups developed plans, started implementing them. That has been producing some results. We're hoping we'll see more going forward. But we didn't really have a clear path forward on the other challenges that were surfaced at the time. So in addition, when we updated our strategic plan, as you recall, we added a new strategy, which is coming up with a roadmap to address all of these potential barriers. And so I went back to the group that had facilitated the initial rocket for us, which is X4, and said, hey, what would it look like for you to help this group come back together and do a roadmap for all of the things that were surfaced in Rocket 1? And so that is what is in your packet today, which is their best take on what it would take to come up with a plan. And then the proposal as well includes what they're calling project accelerator support. So basically they would give us somebody who can kind of herd the cats. So as community partners are raising their hands and saying, we can take this, we can take that, this person who would be an X4 staffer would help with the follow-ups, keeping people accountable. Hey, you said you were going to do this by X date. Where are we on that? Just because normally that falls to Delaney and I, and we are happy to do that, but we sometimes miss those if other things are happening that the court's working on. And so this way we would have somebody who's laser focused on making sure that these are getting implemented in the timely manner. So the next piece of this that I wanted to suggest is if we decide we wanted to move forward with this, we are still sitting on a good chunk of ARPA money, like almost $365,000. And so what I am proposing is that we take some of those ARPA dollars and invest in this process and keeping those community partners around the table and moving forward on childcare. Getting this roadmap in place that we've identified as a strategy. And I asked Delaney to go ahead and pull the ARPA guidelines just to confirm. And so you see that it definitely will cover childcare development and things like that. So I think we are definitely within the federal requirements. And I don't have another project. I don't believe ARPA was covering housing development, for instance, or things like that. I think it was impacts that happened as a result of COVID. And so we're kind of, although they give us pretty broad guidelines, like, hey, improve childcare or something, it can't be spent on just anything.
We did talk about this going towards childcare
Previously.
when we had our first chunk of the
Oh, it's American Rescue.
ARPA payment
American
come in.
Rescue Plan. Yeah, we did. We had talked about possibly using it to seed some of our initial broadband stuff. Now that those big infrastructure dollars we know are coming, I don't know that this is the, I feel like this may be a better use to put toward our childcare situation.
So, oh, I lost that thought. So you said you track the ARPA funds, I'm assuming the financials. Is that what you were saying? You looked to see where we're at with them?
Yeah, so
I didn't see that in the packet.
Yeah, so we basically, I think that the original allocation was like 370,000. It is sitting, by the way, if you're interested in the economic enhancement, that's where it's parked right now.
I thought it was 170, 170. Or something like that. Come in two.
I think it might be a little bit more.
Maybe it's 100. I thought it came in two, and that was one of my questions. We hadn't made the request for the second half.
I'm pretty sure Nathan went and did that.
It's there, we got it. And we haven't used any of it.
We used, I want to say maybe 5,000 for a more core request.
Okay.
But that's it, very little. We just kicked in our percentage. I think they were doing some stuff in their facility, some capital projects that we did our percentage based on the Norfolk formula. But that has been it. We've kind of been waiting for the right project, I think. It's 232 is the fund.
This one says 258.
Is that?
That it might, I don't know.
Yeah, 258, 4199.
Where did I get 365? Oh, wait, no.
Oh, there's,
Is there another one?
Because that was, that's the revenue. So that's what's transferred in. Look down here, American Rescue Plan.
there's an expense.
Right there.
Over there.
Oh, okay.
364. I was like, wait, how was I
Over
that
there.
far off? So that's the revenue coming in, and it does look like he accepted about $250,000 this year.
Let me see that. Okay. Because there was other funds that came from that, other than that, if I remember right, other than the, I'm sure it was like 170 or 192.
Well, it was coming in tranches, but I can't remember how many of them there were.
Okay.
But needless to say, this request is far less than that. So we would have sufficient ARPA dollars to cover.
Well, I think it kind of gets the arm around this so we can track it and move forward. We got some difficult stuff to look at that can help.
And we also have partners who were really committed during the rocket process.
And bring
They were-
back the employers and that to the process.
Yeah, they were part of the rocket, so I would like to continue those collaborations because I thought it went really, that process went really well. And so I think sort of keeping that group together to work on this is going to be important.
Will that be, I mean, part of this would be pulling them in to be more of a partner in the process so that going forward, they're part of the solution?
Correct. Yeah, so one of the things that was raised by Rocket was how do we engage employers more aggressively in being part of the solution?
But we didn't get much out of that in the first.
No, they identified it as a need, but then they worked on some other needs. I mean, there were like 5 or 7 that they had surfaced, so they focused on just the 2, and this would be circling back to catch those other ones that were surfaced, but we didn't have the time to actually address in the first rocket process.
Gilliam County received $371,384 of the fiscal recovery funds from, which is this ARPA fund. That was the total amount for this.
And then there was the minus $6,500.
Yeah, for the.
And that's coming from the final rule on the US Treasury's page with what the delegation was by state.
2 payments or 7?
It just says the lump amount, it doesn't say what payment, but it lists all of the
I
counties
just keep,
and that's how
I'm
much.
going back to my memory spot on how they
I
split
feel like we
that.
had to ask them for each installment.
Yeah.
I think you're right about
I
that.
remember Nathan had some trouble because he had to put all of his personal information on there to make the request.
Mhm.
It was miserable.
Yep. So if, I don't need a motion today, I just need to understand if you guys think we're on the right track. And if so, I will ask Christine, who runs X4, to give us an actual contract language that we could bring back, but I didn't want to ask her to do that if you think I'm barking up the wrong tree, so.
You are working on this stuff. I've got other duties I'm working on, so I like to concentrate on the stuff I'm working on. That just looks like a good way to move this forward, and anxious to see if we can get some support out of the employers and help solve the problem.
Great. Okay, so I will go back to Christine, say that think we're on the right track, and ask and work with legal counsel to get something in writing and bring that back for the court to actually formalize a partnership. Sound good? Okay. All right, thank you for that. We have another executive session scheduled. We are not going to be making decisions coming out of it. So I'd like to do the announcements and things like that. So if folks want to drop off, they can. Obviously, you're welcome to stay if you want to watch us adjourn, but when we come back, all we're going to be doing is adjourning. Next meeting is scheduled for April 5th. That one will be in Condon. Also wanted to flag that our budget season is gearing up, and I believe the first budget committee meeting is April 18th in Condon. So put that on your agenda if you are, or your calendar if you're interested. Pat, what do you have going on?
Well, been a lot of meetings in the last few weeks, but just kind of overwhelmed by meetings. We met with Iris, looking at doing some work with them on moving down the road with the road department, weed department for some inventory control in the weed department and preventive maintenance with the county equipment. So head down that road. Finally, it's been out there a while. And I've been to the city council meeting this month and the Port Arlington meeting, a bunch of AOC meetings, committee meetings. Went to AOC in Salem on Sunday and Capitol on Tuesday, and Eastern Oregon Caucus call both last couple of weeks right in the middle of the session and everybody beating the bills up. So, went to the dinner last night. That was really nice for the Gilliam County Soil and Water Conservation District for their annual meeting. And have Norcor tomorrow and KED tomorrow, and looks like we're gonna be moving into another economic development district tomorrow.
Great. Leah, what are you working on?
So I sat through the ambulance service area plan and we got that hashed out. And I think Chris has got the draft ready and everybody's reviewing it. Then it'll go to the state on the 5th, just to make sure that we addressed all the issues they had in their letter. And then if they okay it, then it'll come back and come to the court to approve. And I went on the tour at Waste and with Leah and I think Paul Wilson drove a little bus around. We toured the waste management site and then we came and had our meeting. My first PAC meeting, got information that I need to read through it and see what I'm actually supposed to be doing. And we had a public health meeting on Monday, so that's it for me.
You're busy.
Busier than
Busy.
last month.
For me, I wanted to flag that we submitted in congressionally directed spending request to Merkley's office for restoring the Liberty Theater in Condon. Merkley's office got back to us and I have a walkthrough scheduled with them next week. They're going to walk through with the Condon Arts Council, and I think Jeff Schott's going to walk through with them to give them kind of a perspective on how this would need to happen. So that is good news.
Who does that? Their office, their staff?
Their staff at Dan Mars.
Dan will be here?
Yeah.
Well, I see on the 6th, he's got a tour of waste management too, that's for the natural gas stuff. So cool.
Yeah, glad to have him out. So hopefully Merkley's office is careful to set expectations that the account that we're going after has I think 1 in 5 success rate. I have gently reminded Dan that we did not ask for an earmark last year. And so we would just like to make sure that we're one of those 1 out of 5. So hopefully they'll be able to deliver for us on that. That's my hope. I also was at AOC this week, earlier in the week, had good meetings with our other county colleagues. And then also on Tuesday, went and saw some of our legislators and had some good discussions around childcare, around the idea of a cultural district being formed in Condon, and some drought relief stuff that Representative Owen's office had asked us for, that we are hopefully going to get sort of a last minute request into a bill to provide some funding to help people who have been impacted by drought in the county.
That's primarily around wells.
Correct. Yeah. So we based it off of what Jameson and Marshall told us, approximate number of wells that they get called, or of pumps that they get asked to come out to, how many replacements they have a year, which is roughly 24, they told us, about 2 a month. And that of those, there's a percentage that pretty consistently end up needing a whole new well because there's just not enough water to support that. And so Herb at SWCD kind of helped me do some numbers that we sent to Owen's office, and also provided to Rep Smith to see if between the two of them, we can get some for that. Did ask for money for the childcare expansion in Condon as well. I'm hoping there is talk that there's going to be a childcare package going through. So hopefully we get a little piece of that for some of the work that the Learning Center is doing on their facility. Let me see what else. I think. I can't remember. Is there anything else that I was planning on sharing? Still working on figuring out a good model for housing. I did go see the Condon School Board last week, and they directed Superintendent Schimmer to start doing some more due diligence on what it would look like for the school district to own and or develop housing for their teachers. And I'm planning, Penny last name, was from the ESD, was at that meeting. And so I kind of looked down the row at her and said, hey, I'm in the ESD too. So I'm hoping to have a conversation with her as well to see if they might have a need. And have just kind of been working my way through employers to try to get a head count of who might be interested in potentially doing a collaborative development. And I think other than that, it has just been travel and working on the things that have been in the packet. So that's what I got. Anything else for this piece? If not, again, for folks who are on the Zoom, we are going to go into one last executive session. We will not be making decisions coming out of it. So if you are wanting to get back your time, feel free to drop off. You are not going to miss anything. Obviously, you're welcome to stay and watch us adjourn. Just want to set expectations. We're not coming back and doing any more business. So with that, we will go into executive session in accordance with ORS 192.6602D to conduct deliberations with persons designated by the governing body to carry on labor negotiations. The Gilliam County Court will now meet in executive session pursuant to ORS 192.6602D, which allows the court to meet in executive session to conduct deliberations with persons designated by the governing body to carry on labor negotiations. Designated staff will be allowed to attend the executive session. All other members of the audience are asked to remain in the public meeting room, while the court reconvenes in a private meeting room. Representatives of the news media are specifically directed not to report on or otherwise disclose any of the deliberations, thanks Jed, or anything said about these subjects during the executive session, except to state the general subject of the session as previously announced. No decision may be made in executive session. At the end of the executive session, we will return to the audience in the public meeting room. Again, we are not planning on making any decisions. We will not be making any decisions coming out of it. So you will not miss anything if you drop off. Okay, do we want to move into the It is 1:18 and we are back in session and we will adjourn the meeting.